For police to seize a person, they have to have reasonable suspicion that the person has committed, is committing, or is about to commit a crime. That reasonable suspicion has to be established prior to the seizure. New Jersey versus Tucker shows us that flight alone is not enough to seize a person. That by itself is not reasonable suspicion that the person has done anything. However, flight coupled with other factors can be enough to seize somebody. And that's what we're about to see in this case. Though this is an unpublished opinion, it does reaffirm several facts that we should already know when it comes to constitutional seizures and investigative detention. This is the state of New Jersey versus KHALIEL Arrington. This is an unpublished opinion decided on December 29th, 2025. On June 19th, 2019, at approximately 12:24 p.m., a person was shot in Newark, New Jersey. Newark officers, including Captain E. Lopez, responded. Witnesses reported a silver SUV left the scene with no last known direction of flight, and a male wearing all black clothing with a black hoodie fled from the location towards Hillside Avenue. Captain Lopez relayed information of the suspects involved in the shooting via radio. Officer Lopez was en route to the location in an unmarked police car 10 to 20 minutes after the shooting when he saw a male fitting the description of the suspect about 2.5 blocks from the shooting. Officer Lopez observed the individual, later identified as the defendant, walking at a fast pace with his hand in his waistband, consistent with a male carrying a handgun, on a cell phone, looking back, extremely nervous when he observed a marked patrol unit and heard police sirens. Officer Lopez followed the defendant and observed him. Every time patrol units passed by the defendant, he bladed his body away from the patrol units and walked faster. Based on the observations, he believed that the defendant may have been involved in the shooting and alerted all officers of the crime prevention team to stop the defendant and detain him to further investigate. Officer Gonzalez and Sergeant Vinuesa responded in a marked police vehicle and observed the defendant approximately 5 blocks from the scene of the shooting. Sergeant Vinuesa identified himself as a police officer and ordered the defendant to stop. The defendant reached underneath his waistband area, removed the black fanny pack, and tossed it to the ground. The defendant then fled. Sergeant Vinuesa recovered the fanny pack, which contained a loaded handgun containing 2 hollow-nosed bullets. The defendant was apprehended after a brief foot pursuit. He was indicted and charged with second-degree unlawful possession of a handgun, fourth-degree possession of hollow-nosed bullets, and fourth-degree resisting arrest. He filed a motion to suppress. The trial court denied the defendant's motion to suppress. The defendant now appeals, arguing the gun should be suppressed because the police did not have reasonable and articulable suspicion to stop the defendant, and the defendant did not abandon the gun because it was dropped in direct response to an illegal stop. The court ruled, courts look at the totality of the circumstances to determine whether reasonable suspicion exists. To that end, courts can give weight to an officer's knowledge and experience as well as rational inferences that could be drawn from the facts, objectively and reasonably viewed in light of the officer's expertise. Officers had a reasonable and articulable suspicion to conduct an investigatory stop of the defendant based on the totality of the circumstances in this case. The clothing the defendant was wearing matched the description provided by the witnesses at the scene of the shooting. The defendant was found in temporal and geographic proximity to the shooting, approximately 2.5 blocks away from the scene. Officer Lopez's observations of the defendant further supported the officer's reasonable and articulable suspicion. Specifically, the defendant was walking at a fast pace, with his hand in his waistband, consistent with a male carrying a handgun, and on the cell phone looking back and acting extremely nervous when he observed a marked patrol unit and heard police sirens. Every time units passed by, the defendant bladed his body away from the patrol units and walked faster. The appellate court did not address the defendant's abandonment argument. The appeal is denied. This was an excellent case brought by the Newark Police Department. These officers not only identified and apprehended this suspect, but also got a conviction. One piece that is really worth pointing out for our officers: observe, sit back, and don't rush if you don't have to. A suspect that is merely armed is not an active shooter. If he just has that illegal handgun on him, make the scene safe. Call additional officers. As you're calling for additional officers, sit back and make observations. document those observations like we see in this case. It was the documentation and that articulation by this officer that got the conviction. I hope all of you are able to do the same if you come across a similar situation in your jurisdiction. I hope you all had a happy and safe holiday season. Happy New Year. Subscribe for more, and I hope to see you at our in-service training in the upcoming year. Stay safe.
This podcast is brought to you by the J. Harris Academy of Police Training. J. Harris Academy of Police Training is based in New Jersey and provides law enforcement training services nationwide for promotional examinations, use of force, supervisory development, and other key areas within law enforcement. This podcast is utilized to discuss key topics occurring within the profession. The opinions and information provided is for entertainment purposes only. In an effort to provide this, we often purposely discuss opposite views and opinions to spark conversation and develop discussion points. The contents of the show and show notes are all copyrighted. All blog posts, podcasts, and show notes that are distributed to the public for free can be redistributed via hard copy or electronic copy for free only if the J. Harris Academy of Police Training is included as the acknowledged author within the actual media that is redistributed. This entire disclaimer also applies to any guests or contributors to the podcast or blog. Under no circumstances shall the J. Harris Academy of Police Training, any guests, contributors to the podcast or blog, or any employees, associates, or affiliates of the company be responsible for damages arising from the use of the information provided.